Hi, everybody. Welcome to our new monthly webinar. We were so grateful for everybody that have gotten to involve throughout the weekly summer webinars. We were able to do 12 of them. As the school year has started, we have jumped over to the monthly one. My name is Sam Alamayo. I'm a 2004 Ram Brown Scholar and on the board of trustee. I have the pleasure of co-hosting your monthly webinar with my fellow board of trustee and co-host Meredith Eggers. Meredith.
Hi, everybody. Thank you for joining us. And I want to remind everybody that this is a place where no question you should not feel like there's any question you can't ask or any comment you can't make. It's a place for conversation. Sometimes the conversation might be uncomfortable and it might be difficult, but that's the point. If we don't have these conversations, we don't move forward. So thanks everyone for joining us and for continuing the conversation.
Wonderful. Thanks, Meredith. Today, we're very, very excited to have two Ram Brown scholars joining us to talk about something very timely and very critical and in line to what we've been discussing about. First, I just want to start out with a quick introduction for all new individuals that are new to the Ram Brown community. The Ram Brown Scholars Program is dedicated to nurturing the next generation of African-American leaders. The scholarship honors the legacy of the late Secretary Ronald H. Brown through a highly selective scholarship program that advances higher education for community-minded and intellectually gifted African-Americans. The program supports students before entering college through the Guided Pathway Support Program, or GPS, during the college years through the scholarship and mentoring, and after graduation through mentoring and networking. Today, we have a very timely topic in discussing on the role of the justice system and the courts, the high courts in our life and in our communities, and also to discuss a bit more about Guided Pathway Program as well, since we have the director of the program. Two of our esteemed, fantastic guests are Carla J. Agahedo, I hope I didn't mispronounce, Ram Brown Scholar, class of 2001. She's a managing director of the Agahedo firm, PLC. Carla specializes in white-collar criminal defenses in federal and state courts. She graduated from the University of Virginia Law School. And we are super, super excited to have Carla, who lives in Houston with her husband and two boys. Kaya Jones is a Ram Brown Scholar, class of 1999. She is the director of the Guided Pathway Supports Program as part of the Ram Brown Scholars Program. Kaya she graduated from the University of Mississippi Law School, where she concentrated in poverty law, earning an Outstanding Student Award in Legal Problems and Indigenous and a Public Interest Law Foundation Student Award. Without further ado, I want to start the questions and the discussion. And Carla, I'm going to start with you. I want to get your view on the very sad passing of the great Justice Ruth Bader Ginsburg, the notorious RBG, and your thoughts about the moment we're facing right now with social justice in our country and the recent nomination of the new justice.
Thank you so much, Sam. And I'm just incredibly grateful for the opportunity to be on this panel and to the Ram Brown Scholar Program for hosting these conversations and having this one in particular. I feel like it's extremely timely. And I feel privileged to be on this with Kaya Jones, who happens to be one of my mentors. Very quickly, I'm rambling, but I'll get there. You know, I'm a 2001 scholar. So all the classes from 96 to 2000 are like the big kids. And even though there's like, almost 15 classes behind me now, like those 4 classes in front of me or 5 classes in front of me are like still the icons in my brain. And so 2 years between us matters very little to you guys now in the context of, 16 classes, I guess, 14 classes. But Kaya, 2 years ahead of me, is like rock star hero status. So I feel very privileged to be here with the rock star heroes, including Sam, y'all know his bio, and Meredith. And one of the rock star heroes, that I want to talk about is Justice Ruth Bader Ginsburg. And I think maybe rambling about Ron Brown and the Scholar Program helped me get over what I felt when you mentioned her name, which was burning in my eyes, tears, and that sense of emotion that continues to happen with the thought that she's gone. And her being gone is both the life of an 87-year-old woman who was small framed and reminded me so much of my great grandmother, who used to always say a little piece of leather, but well put together. She was like 4'10", and 100, there it is, and 110 pounds wet, and here comes Ruth, this literally beast of a woman, at 87 years old, a tiny woman, but oh my goodness, incredible. And I've had the privilege of being in her space because I was appointed as a member of the Supreme Court Bar. And with that, you get to come into the courtroom, which is, oh my God, incredible for all the lawyer geeks in the room. And you get to have the full panel of justices sitting there, listening, you've been presented, you just stand up, okay? But still, right? They know you exist. And then you get to hear an argument. And I saw Ruth Bader Ginsburg in action. And just to be in her presence is incredible. This moment, hearing the news on that Friday, that she had passed, it was just devastating. It was like she had survived for so long through multiple bouts of cancer, besides being 87, which is a good, long, rich life. And I think she was holding on for all of us. I really do. I believe that she was holding on for all of us, not just not retiring, but literally not dying. And so I want to thank her for the personal sacrifice that it takes to do what she considered the right thing. I want to honor her life in that way right now. And we have to know that the role she played and the side that she usually landed on in controversial issues, at the end of the day, was where we needed her to be. I say we, I speak of women, I speak of people of color, I speak of the disadvantaged, the underrepresented, all of that. I'm in plenty of intellectual circles with lawyers who pontificate about how she could have been more, for the transgendered woman, and she could have been more for people of color. And, she only appointed one Black clerk in her entire history, starting in, I think, 93 when she was appointed to the court. Okay, thanks for sharing, right? I appreciate the intellectual moment, right? But at the end of the day, in the 5-4 splits, or the 4-5 splits, Ruth was on the right side of the cases, as far as I'm concerned. And that's huge. And so, obviously the second piece of that is her passing creates an opportunity for there to be this political moment of whether and when a nominee will replace her. And at this point, everything is pointing to the fact that Trump, by the way, has nominated, if everyone has missed that, has nominated an appointee. And there is little to nothing that the Democratic Senate minority can do about that prior to this election. And very quickly, we all understand that there was a completely different position taken with at least 6 months before the election, the last time, with President Obama having an opportunity, and the hard line was not an election year. We can't appoint someone in an election year. But here we are, less than 3 months from an election, and the story from the exact same players has changed. So that's my setup. I'm sure there's more to dig into, but that's the answer I'll give right now.
No, absolutely. I think you've set it out very important. Like, it's such an important time. Her role of what she had done and the contrast between who's replacing her is such a stark contrast, and an important time to have a lot more conversation. And I echo what you've said about Ron Brown scholars ahead of us. For me, you're all only ahead of me in 3 years, but yes, like everybody, I'm 2004. All of you are the elder statesmen, even the 2003 ones. Because when I was going through kind of school, in high school, I looked at your bios on the website every single day. Use that as a blueprint. So yes, for me, for you, kind of, I know how you feel on Kaya, because I feel the same way for two of my beautiful, beautiful leaders and intellectuals, and for what you continue to do. I admire you, and yeah, it's exciting for me. So I'm like a kid in a candy store. The same exact question to Kaya. You know, the legacy of the notorious RBG has been truly phenomenal. Not just what she has done in the court, but an unprecedented way to be able to connect with a younger generation, to be able to feel, to be relatable to kind of our community. And the thing is, at the end of the day, for, as Carla had said, for minorities, for women, she represents a lot more, and she really signifies what she has done before she joined the court and after the court as well. Where do you see kind of, I want to know your thoughts as well about the moment we're facing right now in light of this nomination, this new nomination, as well as the overall election that is going on, and the social unrest that we're seeing at this time and age?
That's such an important question. But first, I just wanted to give my just wholehearted thanks to Sam and Meredith for convening this. I'd like to keep this mutual admiration going. I wish that all of my fellow Ron Brown scholars and all of our captains and navigators could have the privilege of seeing Sam and Meredith advocate for us in Board of Trustees meetings. You can tell that, you know, when they walk into the room, they bring to bear so much love and respect for the program and genuine care for our scholars. So thank you so much for organizing the Salon Leadership Series and giving us the chance to speak with candor and care to our community and the friends of the Ron Brown Scholar Program that are scattered around the globe. And it's so interesting, just before the webinar started, Carla and I were joking about how Sam and his picture on the back of the cover of I Have Risen, and just so much admiration that we have for Sam. So for those of you who don't know, there it is. Thank you so much, Meredith, for hunting down that book in your house. So Sam is featured on the back cover of I Have Risen in this incredibly beautiful photo. And I was telling Carla and Meredith that at the time that I Have Risen was being created, and the three photographers who created all those beautiful photos, I was assigned to Clarence Williams III, who had just photographed Sam. And so while I'm riding around LA with the photographer, he can't stop talking about how wonderful Sam's photo was. And so I was joking with Carla that I felt like, well, should I go get a rooster? Would that make you engage my photo? Because I can do that. It still won't be as great a photo as Sam's. But I definitely, you know, for a long time have admired Sam and his wonderful origin story and just his lived experiences. And it's so interesting to hear Carla speak about me as being the big kid in the room, because as soon as I met Carla Hardy now, a ghetto from Tyler, Texas, I felt like I had met almost like a sister. And we have known each other for what seems like my entire life. We've prayed together, and it's just been a privilege to watch her growth and development through the years. And so it's great to be here among friends and loved ones. So that being said, let's address the question and how we handle the passing of Justice Ruth Bader Ginsburg in a country where we are not surrounded by our loved ones, where we are led by a president that has openly allied with white supremacist groups, many of those groups who we know actively participate in paramilitary activities. And so now we are in this place where we are looking for leadership. And we're really fortunate to be here in this moment in time with the Black Lives Matter movement, which has evolved into the largest civil rights movement in U.S. history. And so this moment was meant for this time. I feel like we're prepared to meet the challenges of the day. I feel like we have the tools and the resources that we need. We've learned so many lessons from the civil rights movements that have preceded this time. And we've also learned, most importantly, progress and how to marshal patience and how to demand change now. And I've been saying for maybe the last year to 18 months that so much of what little political stability that we have now rested on the Honorable Ruth Bader Ginsburg's pancreas. She was suffering from one of the most, debilitating types of cancer that's known. And so for her to continue to fight, continue to serve as a zealous advocate, should really be an example for all Americans, not just progressives, not just for those who interpret the Constitution the way that she does. I mean, that's just an incredible example of public service, to give your all up until the end of your life to the difficult task of serving others. That's an example that we all needed as Americans because we are not getting it from our presidential leadership. But when I think about her passing, mostly I think about a diminished equal protection clause. I'm mourning the loss of life, but I'm also mourning the threats that we face in terms of our civil liberties and how those statutes that rely on the 14th Amendment in order to have our civil rights enforced as women, as minorities, as religious minorities, as people with disabilities, so many broad swaths of every American, and how the people who populate the highest bench have the authority to interpret those statutes to diminish those liberties. What we lose with the replacement of RBG with Judge Amy Barrett are all of those guarantees of the 14th Amendment. She has openly said that she will interpret statutes and she will serve as a person who hews closely to the views of the late Justice Antonin Scalia, who many of us know has a very limited interpretation of the 14th Amendment. And so all of those incredible advances that we've made just in modern U.S. political and legal history that rely on those broad interpretations of that one particular amendment are at threat. Most of my background has been in voting rights, and I should let everyone know, to be fair, I call myself a recovering lawyer. I do not practice, although I have graduated from law school. I focused on poverty law. Most of my previous work experience has been in managing and leading statewide voter registration and ballot initiative campaigns in California, Ohio, Wisconsin, and Florida. I also had the privilege to work for the Lawyers Committee for Civil Rights in Chicago to help with some voting rights cases for minority political groups throughout Chicagoland, and have also worked on projects to restore felon voting rights in Mississippi and in Virginia. And so when I think about, especially in terms of voting rights and RBG's legacy, those rights are literally at threat. But now is the time for us to step up. We start to advocate at the state and local level. We will fight what we anticipate will be acts of voter suppression and voter intimidation, and we will work to try to expand the franchise locally. And I think that that's what the late Justice Ginsburg's legacy requires.
Once a lawyer, always a lawyer. Just want to make sure I put that out there.
Please don't say that. Please don't say that. I spend most of my days trying to forget.
I love it. I think you guys both bring up incredible points about the impact that RBG had on the court. So my follow-on question to you is, and I say this facetiously, is the court really that important? why does it matter? Why does it matter beyond, how does it matter on Main Street?
I'd like to jump in to tackle that if I can, because I really love that question because it made me ponder a few things. I don't know if any of them are necessarily valuable to others, but I will share them nonetheless. For some reason, it made me think about this push to incorporate more artificial intelligence within the judicial process and within our judicial systems. Now we have AI platforms that are able to perform legal research, that are taking on more tasks that law students and lawyers would have previously done. We have, sentencing decisions that are being made by, artificial intelligence. And so it made me ponder, are we moving toward a direction where we could anticipate that in some capacity AI could replace the judges who sit on a bench at a local or state level? And if that happens, it's only a matter of time before it could happen to, federal benches or even the highest bench. So what would be lost if we replaced, the U.S. Supreme Court in some capacity with some kind of software? And it made me really appreciate how the discernment that goes into statutory interpretation and how just weighing certain facts when interpreting statutes really requires not only an incredible jurist, and I know that these are my personal opinions, but it also requires an incredible human, someone who is willing and able to look outside their own lived experiences to consider certain facts or to consider, certain circumstances that should influence the way certain laws are interpreted, in my opinion. And so I inevitably came to decide that who sits on that bench really does matter. Not only do they set precedents that binds us for generations, it is a virtue signal throughout state and local governments, really throughout the world, to establish a baseline of what we uphold. And so, say what you will about, how politics has influenced the bench, how they hear so few cases, and how, most Americans are so far removed from some of the decisions that the Supreme Court makes. But those decisions still reverberate throughout the world and still impact us today. But equally as important, I think, are also the people who populate our state Supreme Courts. Many of them are elected in uncompetitive elections. And now, if we anticipate that Judge Amy Barrett will be nominated and will be seated on the bench, and we anticipate that, many of these close decisions could be harmful to certain civil rights and civil liberties, then that puts primacy on state courts. Especially state Supreme Courts, to uphold those rights under their state constitutions and their state laws. And so it is equally as important, the people that we have, especially at this time, who are sitting on those state Supreme Court benches as the Supreme Court, in my opinion.
Spoken like a true non-lawyer. So anyway, Kaya, I have got to I'll try to let it go. I'll try to let it go.
I have to mute myself whenever you're on, because all you hear is cackling.
What did you say? I'm sorry. What did you say, Samuel?
No, just we need her at GPS. You cannot, try to pull her back into a court. No.
Fine. That's
Stay
fine.
away. Like, we are happy as for her to be a non-lawyer.
No problem. I'm being presumptuous. Meredith, do you want me to take this question as well? Great. And I am going to play devil's advocate. I'm a lawyer who's going to say, no, it doesn't matter who sits on the Supreme Court. My real answer is yes and no. I'll take the no because Kaya just handled the yes. And here's why I say this, because so much is happening at the district court level. So Kaya highlighted for us what's happening in the state Supreme Courts. And let's all get comfortable with the fact that we have a state court system, right? And we have a federal court system. And the state courts are always going to handle more cases than federal courts. And that means they're going to have more impact on people's everyday lives than any federal court ever will. Okay? Your child custody cases, your divorce cases, criminal cases, everyday run-of-the-mill criminal cases. Okay? This is happening in state courts. And to Kaya's point, there are state constitutions where the federal constitution sets a floor below which you cannot fall when it comes to rights for human beings who live in the United States. And the states ideally provide more rights, you know, and help make things a little bit better for people. So there's so much going on in state courts, and there's so much influence by state politics and who the prosecutor is. Let's talk about that. Okay, who that assistant district attorney is, who that attorney general is at the state level. Okay, but get over into the federal court system that also has some criminal jurisdiction, and it's constantly expanding. Okay, we know that there are many drug laws, for example, or arms laws, weapons laws that are federal, and they come with some hefty consequences. There's so much play at the district court level. And just, again, understanding the lay of the land. In the federal court system, you start at district court. And of course, they handle civil and criminal cases, just like you can have civil and criminal cases in state courts. But you know, I'm a criminal lawyer, so I think a lot about what's happening in the criminal courts in the Fed system. Okay, and those, what do we have? 294 federal district courts around the United States. Okay.
You're the pastor here. We'll have to take your word for it.
Okay. And those courts, the district courts, the first stop, have been stacked by the current administration with conservative judges. And so the decisions that are being made there, the opinions that are being handed down there are impacting people's everyday lives. And then there's a question of whether that opinion will get appealed to one of our circuit courts. Okay, we've got 1 through 12 plus federal claims and the DC circuit. All right, so 1st through 12th circuit, and then federal claims and the DC circuit. And at that point, with those 14 courts, things have been stacked. Okay, Amy, our friend, I'll give her title and her respect if and when. Okay, but at this point, Amy was appointed under this administration to a federal circuit court. And there's a lot of gameplay happening there. Okay, our friend, Kavanaugh, federal circuit court judge. All right, so a lot of different decisions are being made there. And why does it matter that we move from district to appellate? Because the standard of review changes when you go from district to appellate. So your district court is looking at the facts. They're making decisions based on that judge's, you may have a jury, you may not, but the judge as fact finder or as weigher of what we're going to do next, right, gets reviewed basically with a abuse of discretion standard on most issues, like the factual issues. You ask questions like, oh, why did this white defendant get 3 years probation when the Black defendant with the exact same offense get 10 years, right? Well, we have built into our system the idea of prosecutorial discretion first. So the prosecutor, some random guy, is deciding whether they're going to bring the case. Then they're deciding what sentence they're going to recommend, right? And they're not making it, they recommend it. However, once they recommend to the person they see every single day on multiple cases, right? That relationship between judge and prosecutor is an intimate one because they literally see each other every day, okay? So once that prosecutor recommends something to that judge, it has a lot of weight, okay? And then that judge is making a decision, implementing a sentence that is going to be reviewed on a pretty high standard if and when it ever goes to the appellate court. And of course, we have different standards of review based on what we're looking at. Okay, whether it's a factual question or a question of law. On a factual question, it's usually abuse of discretion. On a legal question, it's de novo review, which means that the circuit court will look with new eyes, de novo, with new eyes at the application of the law to the facts, okay? But the standard just keeps getting raised. So once the circuit court affirms what happened at the district court, meaning everything's cool here, nothing to see. Yes, they made mistakes. By the way, I've read so many opinions. Here are the 15 mistakes that were made at the district court level, but none of them rise to the level of being able to overturn or issue a new sentence. Affirmed. Let's move on. Your next stop is to go to the Supreme Court that grants cert on less than 2% of the cases that come to them. Cert is, yes, we'll review you. We'll give you the opportunity to be heard. And after we've given you the opportunity to be heard, we affirm, okay? I'm not saying that it's always like that, but you know, the point is the further along you go in this process, the harder it is to change anything because our standard of review, the ruler that is used, gets harder, okay? And now you're up there with 9 folks who have thousands of cases coming in. They choose less than 2% of them to review. And about 80 decisions actually get reviewed with opinions issued every year. So that's why I say it doesn't matter who sits on the Supreme Court. We need to be paying attention to who's been appointed at the circuit level. Before that, who was appointed at the district court level. And these 2 levels have been significantly stacked long before RBG, rest her soul, left her seat. I got more to say, but I'm stopping right there.
Well, so I do want you to talk a little bit more because I know that the 4 of us know that you have some pending judgment with the highest court in the land. So talk about that for us. Talk about what you're dealing with as you come up against hoping that you'll get a cert.
Yeah, woo, thank you. So right now, woo, literally, I wrote my first ever Supreme Court brief to the highest court in the land in June of this year. Incredible. And incredible to be doing it as a solo lawyer. I'm talking about so low that I don't have any help. My helpers are 4 and 6 and a disgruntled old man. Okay, they're not helpful. Like literally, can somebody call me and ask if they want to be my assistant? Okay, it's intense. Things like old rules, y'all. I mean, just imagine it. It kind of has like a mystique to it that makes you respect it. And it's also like, but seriously, you want 40 printed copies on paper that's 6 by 9 inches? What? Who does that? Like every other court that I've filed anything in, it's file electronically and move on with your life. The Supreme Court of the United States needs me to send them 40 bound copies on the most random sized paper ever in life. So I'm just putting that out there. If you didn't know and you like try to look up the rules like 2 days in advance, your stomach is going to sink. And I didn't you know, look up the rules 2 days in advance, but like even 2 months in advance is devastating. Okay. And I did come from a global law firm, you know, with 2,500 lawyers in 48 offices and 500 in our DC office. And I pretty much never worked on a team with less than 5 attorneys, unless it was one of my pro bono matters. We can talk about that. But so here I am making this transition at the end of March. And now I have a Supreme Court brief to file in June. Woo! But I did it. By the grace of God, the court is reasonable, and they issued an emergency order due to COVID-19 that said you only have to send us 1 copy on regular 8.5 by 11 paper. And I was like, thank you, Jesus. Thank you. But I still like spent the night, you know, or not the night anymore because with COVID-19 hours have been reduced, but I spent sort of the early morning waking hours into the late night hours at FedEx, Kinko's, and part of what's being recognized by that order, which I appreciate. So I'm saying this because the courts can be practical, right? The courts can be flexible. One of my points is that the courts are conservative inherently. That's what they do. And their job is to make sure things don't get overturned easily. You know, stare decisis is the concept, so that we have integrity in the way that we make our decisions. So part of my reason for saying it doesn't matter who's on the court is because it's an inherently conservative institution. And that conservative has not been picked to be political here. It's just to say the goal is for it to not change, or not change very much. So thank you for having rules that are antiquated regarding 40 copies. Thank you for changing the rules in acknowledgement of the fact that FedEx is not open 24 hours during COVID-19. And thank you for the privilege of being able to file this case on behalf of a client who was charged with healthcare fraud, convicted in the Southern District of Texas, happens to be a Nigerian American woman. And you see on the transcript in the trial, things like, well, we're concerned that she might flee because she has ties to Nigeria, and she, you know, was recently visiting there, and we see that she sends money there sometimes. And my clients are like, that sounds racist. And I'm like, yeah, but there's really nothing we can do about it, because it's linked to the idea of potential flight. And so no one's going to call that out and say it's race, it's gender, it's ethnic. No, there's a rational basis here. This person is significantly tied to whatever other country and has visited there recently. And so it's perfectly normal for us to talk about the possibility that she might flee. But I did want to point that out. These conversations that sound racial, that sound ethnic, that sound gendered, once it gets filtered through the lens of the system and the opinions that have been made in the past, sound perfectly normal to all the lawyers in the room. And it can be scary for that reason. Anyway, convicted, got one of the longest sentences for what she was charged with, 9.5 years, appealed to the Fifth Circuit where she was affirmed, or the conviction was affirmed, but we had a dissent that was helpful. And then I was called in to do the Supreme Court appeal, as well as to handle federal habeas, which is a collateral attack that you can make on the sentence once you have exhausted all of your direct appeals. And so going to the Fifth Circuit is a direct appeal. Requesting rehearing there is part of the direct appeal. She did not get the rehearing, and then going to the Supreme Court is part of the direct appeal. If we get denied at the Supreme Court, then we do the federal habeas petition, which goes back to the district court, and it's a collateral attack. And to my earlier point, all the errors that may have been identified, and in fact have already been identified by the Fifth Circuit, but they said it's still fine, okay? All those errors are now going to be judged at an even higher standard of review on a collateral attack than on direct appeal. So I was hired basically in a losing case. And I'm excited about the opportunity, because I love to stick it to the government and point out all their errors. That is my jam. However, I cannot say that we are preparing for oral argument in the Supreme Court. We are preparing for a swift denial of our petition so that we can move to the next step. And that's just being realistic. But
I'd like to just add a few comments. My stomach hurts just because I have been laughing so much, Carla, at your very candid approach and the way that you have communicated this really difficult case to us. And thank you so much for explaining the Supreme Court filter. And it was just one of the problems that really, I mean, it just took all of the wind out of my sails when we would take poverty cases in Mississippi. You can start with this case that is clearly and totally racial, that just reeks of bias, and then by the time it filters through the system, it's been diminished to this procedural claim, or, you know, all of the facts that made it distinctly racist or punitive to the poor are diminished. And so that it now looks like it's totally racially neutral, that it applies to everyone equally. And so it seems as if the outcome is bound to be negative. And so it's hard to really see any progress when it comes to civil rights in terms of race or helping those who are poor. We specifically saw this in voting rights cases. It reminds me of when the state subject to federal preclearance under the voting rights after the Shelby v. Holder decision didn't have to have those laws anymore. And just as a background, so as we know throughout history, the southern states enacted incredible racist laws the voting rights of Black people. And so they were subject under the Voting Rights Act, Section 5, to preclearance, which meant that if they made any changes to their voting rights laws, they had to be pre-cleared by the federal government to make sure that they were actually fair. And Alabama came in 2013 or 2010 and said, well, we want to make these changes. We don't believe that they will make it harder for Black people to vote. Now, mind you that this is in the midst of the explosion of voter ID laws throughout the country. And I know particularly in Alabama, they had required voters to have a certain type of ID. At that time, you couldn't get a free ID if you didn't have an ID. It was impossible to get a birth certificate. It was impossible to find a place where you can get your ID at convenient times for you. Sometimes they were only open from 1 to 4 on a Tuesday, and there was no public transportation infrastructure for those poor people without transportation to go get the ID just so that they can vote. But Alabama said, oh, there's nothing to see here, and because of the composition of the court, in Shelby v. Holder, they decided, okay, southern states no longer have to get their voting rights changed, no longer have to have their voting laws pre-cleared by the federal government. And so then we see this huge explosion, an even bigger explosion of voter ID laws. In Mississippi, this was especially pernicious because you had a lot of older, rural, African-American people who couldn't even get birth certificates because they were born at home. And so you don't have a birth certificate when you're born at home. And so you wouldn't necessarily have the documentation to get a birth certificate. And then we had clients who fortunately were born in hospitals, but it would take 2 to 3 months just to get an official birth certificate from the Mississippi Department of Vital Statistics. And that doesn't help you when you need your birth certificate to get your free voter ID card so that you can vote. And yet these district courts have routinely held that this doesn't impose a substantial burden on voting. If you have to drive hundreds of miles, as was the case in a case in Texas, if you have to drive hundreds of miles just to get to a DMV so that you can get your free voter ID card so that you can vote, that's not a substantial barrier to voting. And so it takes the wind out of your sails when you see how little relief there can be. But we should be heartened. If there's anything that this recent movement has taught us is that the law is but one tool in our toolbox. We know that so many of these legal issues are decided by political questions or politically, and so that means that meaningful representation in the political sphere matters. That it's not only important to have Black people and brown people and allies taking on these elected positions and appointed positions, but that they can work locally to help influence some of these things where the courts can't provide relief. And so I'm still heartened, but I know that it's going to be really difficult, especially in terms of voting in this cycle. I anticipate that there may be, tons of voter intimidation and voter suppression. If anybody feels like that they are the witness to voter intimidation or suppression, there are some resources and tools and free hotlines that they can call in order to make sure that nothing weird is going on in polling places, as many people anticipate will happen. And so we're at this interesting place where we know that the bench cannot provide relief on certain issues, but we also have the momentum now to elect people who look like us and who actually advance causes that can promote racial equity and that can help those who are low income and working class. And so we just have to tackle them, I think, in the state and local arena.
I think that makes so much sense. We've got a really good question that's come in from the audience, and it speaks to what you're talking about, Kaya, right now. So I thought I'd go ahead and throw it out there, and if you guys can both address this. And then the second part of this is you talked about some resources that would be helpful for folks dealing with voter suppression and dealing with what the question I'm about to ask. So if you can forward those to Sam or me or both of us, when we send the recording of this out to everybody who participated or who comes back and listens later, we'll make sure they have access to that information.
That's fantastic.
We would really appreciate that. So this question may or may not come from a lawyer, but it says, what can lawyers that don't practice election law and non-lawyers do at the local levels to address and prevent voter suppression? So I think call to action, what can all of us do right now in this incredibly important moment to just help in any way that we can?
Kaya, I'm going to jump in because I know you've got a lot to say. You're in this, and I want to make sure everybody's catching this, right? That Kaya has left lawyering so she can help more people, right? And be involved in broad scale campaigns that look at policy issues and sort of zoom out and take a big lens. The lawyer who represents clients like me, gosh, I'm like in this one client's case and it's just like zoomed in, right? And I think about how if I could win this case, it might help, set precedent for someone else. But I tell you, it is the difference between having your head in the sand, looking at this one person and their facts and getting completely wrapped up in it, versus being able to take that wider lens view and look at policy issues. So I think this is a rich discussion just because of that, difference in the way we jump in. So not practicing election law now, I definitely represented a client at one point who was charged with election fraud, and thankfully we were able to successfully resolve that. Black candidate, black elected official who was charged and went through a lot as a result of that. So I'm really a lay citizen on this, not the election lawyer. One thing I'm doing is with the group Vote Forward, okay, nonpartisan group. I am writing letters to voters. So that's number one. And basically they give you go in, you sign up for an account, you go, check a few boxes to make sure you're legit. And then you are able to adopt a set of voters and write letters to them with their address and all of that. So it's, there's some sensitive information. So it's not like everybody can just jump in. You have to make sure you have an account and all of that. But it's not that difficult either. Go in, download these letters that are pre-printed. There are certain parts that you handwrite to personalize it, okay? And then we're all dropping these letters in the mail on October 17th. My friend in Maryland hooked me up with it. I'm down here in Texas. We both have lists of voters in Texas. So I think that's saying something. I think there's some prioritization of battleground states, okay? So that's one thing I'm doing with an organization called Vote Forward. And it got kicked off by a letter writing party hosted by the cast of Hamilton, which was just like so awesome. So I'm writing my letters, and then we have a break where they teach us some dance moves from the musical, and then they come on and sing some songs from the musical. Oh, it was incredible, okay? But that's something we can do. We can write letters to voters, and Vote Forward is a nonpartisan way of doing that. I think the second thing is there's a paucity of poll workers right now. And again, elections are local. These elections are run by states, okay? The feds are the watchers to make sure that there are no constitutional violations. But it's like you know, you show up to the polls, and like random old ladies, we love them, they're awesome, but are running things that are going to make a huge difference. And when those older people can't come out because of COVID-19, right, we don't have what we need. So you could volunteer to be a poll worker. And I think in some places they pay you. I can't say one way or another because it is state by state, which means it's county by county. But that is something. And then the third piece is to be a poll monitor through a different organization. So if you're going to be a poll worker, you're going to be going through like your state election commission. Okay. If you are a poll monitor, there will be multiple third-party 501c3 type of organizations that will set up monitor systems. And some folks will be managing a hotline where people call in to report that there was voter suppression and we need someone to show up. We need lawyers over there. We need whatever. And others will actually be at the polling location, identified with some nonpartisan shirt. Let's be clear about that, because the parties are going to monitor as well. And if you want to go through a party, that's on you. But there are some nonpartisan third parties where you can be a poll monitor. It's just eyes and ears of what is happening, okay? And we know that voter suppression is going to be an issue if the response to the question at the presidential debate about whether you're going to accept the result of the election is, I'm telling my voters to go to the polls and watch and see and pay attention to what's happening, i.e., I'm setting everyone up to question the result. I'm putting it out there right now that our democracy doesn't work very well unless you watch and see and I get elected. So yeah, and then the other question about white supremacy and whether you would deny it here on the stage was, stand down, guys, but stand by. Something like that, right? So I'm thinking, reading between the lines, that's a call to action for you to engage in some voter suppression. And you'll have the backing of the highest court in the land to do so. And so my 3 responses: write letters to voters to get them engaged, consider being a poll worker on that day, and consider being a poll monitor, either in person or through being on a hotline. And those groups will engage the folks who can further help and take legal action to address those issues.
I completely agree with each of the 3 suggestions that Carla made. I would also suggest that you know, if you decide to volunteer as a poll monitor and you can safely do it, you know, one of the best things that you can do is document if there are, you know, armed people who are outside of the polling place, or if there is illegal electioneering. Some places, some polling sites don't allow people to come in with stickers that endorse a particular candidate. You just want to monitor those things. And just quickly, so that everyone has it. So the National Lawyers Committee for Civil Rights, every year they put together a voting rights hotline. And if you see anything, you can call this hotline. If you have a ballot that's challenged, if you see some strange things happening at a polling place, even if people don't know where to go to vote. And the number has been 1-866-OUR-VOTE. OURVOTE forever. I know that they've been doing this for at least 10 years, probably longer. And so you can call that number if you witness anything while you're out. I would also suggest that for our Ron Brown scholars and captains who are in college and all of those who are listening, you know, talk to your peers to see whether they are having their residency requirements challenged. If you are back home because you're forced to be home because of quarantine, some districts impose really restrictive residency requirements that may say, well, even though this is where your parents live, you can no longer vote here. And then the same thing happens on your college campus where they say, well, you haven't established yourself as a permanent resident, so you can't vote here. So just make sure that your friends who want to vote are eligible and aren't being thwarted by those residency requirements. And if something weird is happening, if there's no polling place on your campus, if you're there where normally there would be, those are things that you can call 1-866-OUR-VOTE. to help tackle. In terms of bigger picture things, I would just suggest that one of the biggest problems to voter suppression is just gerrymandering. That's why I cringe so much when people say every vote counts, because we're already packed into these districts that are created and designed to diminish the power of the African American vote. So if you have any interest in GIS mapping or any background in software engineering, you can teach yourself in a relatively short period of time to use the software that determines where these political lines are drawn. And there's just a severe lack of African Americans who have this expertise. And in fact, one of these most prominent people who was an expert in that type of map making has been recently discovered as a racist who was relied on, his services were relied on by Republicans throughout the country to craft these maps that pack African Americans into political districts or that divide them to dilute their power. So I would say that expertise is needed. We also need more African Americans running for Secretary of State, more African Americans who are paying attention to the voting machines that they have available in their polling places. A lot of our voting machines, I would say most of our voting machines, are just not secure, and it is impacting us. Some people would argue that Stacey Abrams lost an election due to those insecure voting machines that were proven that could be hacked with images of the 9/11 attacks and pornography. And so paying attention to the state and local levels at what your local elections office or what your local commissions are doing when they are setting these rules for polling place hours and what machines they'll use, all of those things matter. And so just by paying attention and then engaging, we can see impacts, if not in this election, in future elections.
Wow, very super valuable. As we're coming to kind of the end of the hour, one question I just wanted to add in there, and it's coming together on, the important thing at the end of the day is this is one of the tools in the toolbox for justice, but are we relying too much on the courts, especially on the Supreme Court? So every time when a new justice passes away or there is a nomination process, very important issues like Roe versus Wade and many other important issues are always on the line when they shouldn't be. They should be a law. And one of the key thing is the structure of the electoral system, as well as the fact that we just do not have the majority voice is not being reflected in the legislators. So what is your message on, are we relying on the courts a little too much to make laws for us or to protect the laws that we care about?
I would just jump in and say yes. That's my short answer. Sorry, not to cut you off, but I'll be brief so that Carla can also respond. Yes, we over-rely on the judicial system just because it's been proven throughout history that it's provided, the relief that it can extend to African Americans can be limited. And so we have to rely on political systems, local government systems, and just our own communities and our own nonprofits and social services to provide relief where courts just cannot or refuse to do so.
No, we do not over-rely on our judicial system. I am so grateful that there's checks and balances. I don't know, I drank the Kool-Aid in 3rd grade when I learned about these checks and balances. And I will say that our current administration is doing everything it can to say there's no check and no balance on presidential power. And he's got some very tough scholars on his team, smart as a whip kind of people who've been writing about this for years, who've been wanting to push for this, of course, only under their type of administration, right? Because they also criticized the Obama administration for overextending their power, using too much of presidential power to get things done. We're talking about executive orders versus waiting for the legislature to pass laws. So I just want to go back to the basics, right? That the legislature is supposed to pass laws and we need people to vote. That is why this voting conversation is so important. We need people to vote and engage at every level in our national elections that happen every 4 years, in our congressional elections, midterms that happen every 2 years, and in state elections as well, whenever they're happening, okay? That we need to get engaged, because the legislature is supposed to be making the laws. It should be reflecting what we want and what we need as the electorate, as the people who are being served. And when the legislature is full of idiots, I'm comfortable saying, sometimes, or at least not, if it's not full, it's overrun by idiots, out of balance, okay? We need some check, right? Which is our judicial system, okay? On that. And I'm so comfortable with that, because our judicial system is interpreting the law. What did they say? How do we interpret it? 2 questions. Well, what do we think they intended to say? And if we figure out what they intended to say, is what they intended to say consistent with our Constitution, which is designed to protect us? And we can have an intellectual jaded conversation about how it doesn't and it never did and blah, blah, blah. But there's been a lot of progress made on just using that Constitution to push back on, you know, anytime idiocy gets out of balance in this branch. And then you have this third branch, which is supposed to enforce the law. These guys made it. We elected them to do it. This guy enforces it. This person checks both of them, right? The judiciary checks both of them on whether it was right to make it and are you enforcing it in the right way. And we have seen this branch, the presidential branch, obviously expand its power, one, by executive order. So it's creating law through these executive orders when it's, you know, there should be checks on it. And 2, by literally flipping the bird to the other branches, particularly the judiciary. And that was the one that scares me. You know, this interaction between the president and the legislature is inherently political. But this interaction between the president and the court needs to be filled with respect. I just believe that, because these people are not here as political actors. They're here as watchdogs. And then we know, once we look deeper into them, they're political too, okay? But we have set it up to where this judicial system is generally designed to protect through that oversight of interpreting the law. So, you know, I'm just putting that out there. It's a definitely a relevant conversation. It's an important conversation, but don't let the answer be, oh, I sat at home in November because the Supreme Court doesn't matter. That would be my bottom line. Me and Kaya can agree on that. Get yourself out there and vote, and do what you can to protect the vote for others as well.
And that is just an incredible point to make. It should be so obvious, but it was eloquently stated and helpful and inspiring. And I think you all have given us hope. You've given us some really good things to do right now. And like I said, I captured some of the notes and put it in the comments. But if there are any other resources that we can send out to folks, we will certainly do that with the links. And as always, another phenomenal panel. Thank you, Sam. Thank you, guys. I'm going to pass it back to Sam to close off. And we will have a schedule out for the rest of the fall shortly. So stay tuned.
Thank you so much, Carla, Kaya. I was writing notes and just being a student back in. So really love what you're doing. Thank you so much for taking the time to come and talk to us. And we will continue to reach out to you for your wisdom. And we've put out the word for an apprentice and an associate to be working with Carla and support
it's in the chat. So we'll let you know when we start to get CVs.
There are lots of interns out there that could definitely virtually could learn a lot better. Meredith, as usual, thank you so much. Thank you, everybody.
Everybody, let's get out there and get it done in a few short weeks. Let's be on a happy note the next time we all come together, please.
Yes, definitely.
Happy Thursday, everyone. Thanks again.
Thank you. Bye, everybody.
Thanks. Bye, everybody.
Bye.